One question we would like both parties to address, because our central job on remand from the Supreme Court is to figure out exactly what the scope of our job on remand from the Supreme Court is we'd like each party to tell us exactly what your view is of the scope of our task on remand from the Supreme Court, how we are to review the record of the case in light of the task the Supreme Court's given us in the masterpiece case, in remanding our case for reconsideration, and to the extent you can, what legal standard we should apply in reviewing the record and conducting our job on remand. And with that, we will hear from petitioners first.
May it please the court and counsel, my name is Adam Gustafson and I represent appellants Melissa and Aaron Klein. Under Masterpiece Cake Shop, the free exercise clause requires neutral and respectful consideration of the client's claims in all the circumstances of the case. This neutrality must be strictly observed, the court held, because even subtle departures from neutrality violate the Constitution. Boley's order must be reversed because the Commission showed hostility toward the client's sincere religious beliefs in 5 mutually reinforcing ways. The court's task at hand is to examine first whether similar deviations from neutrality have happened in this case, and if the answer is yes, then the precedent before the court requires reversal. That was the outcome in Masterpiece Cake Shop. The court said that the case must be invalidated. If the court were not to find that there was a lack of neutrality in this case, Masterpiece Cake Shop still provides guidance on how to address all of the arguments that are still before this court, including on the free speech claim. Imagine a judge who posts on Facebook a news story about a shooting and then writes, "Everyone has a right to defend himself, but that doesn't mean he can shoot another person in cold blood." What sounds like a general statement of law takes on an entirely different meaning when it's said in connection with a specific case. Could that judge then sit as a neutral arbiter of the shooter's self-defense claim? That's essentially what Commissioner Avakian did in this case. Before it was even before him, he posted a news story about it on Facebook and wrote, everyone has a right to their religious beliefs, but that doesn't mean they can disobey laws already in place.
Counsel, can I stop you at that point? Because that touches on one of my first questions, which is, if you assumed for a moment that the Court of Appeals in its prior decision got it right on the merits, providing an intermediate standard of review on the speech claim, and then looking to the religion claim, if the Court of Appeals, if we got it right before on the merits, and I respect and recognize that your clients disagree on the merits, so I'm not asking you to concede that, but if you assumed that the court got it right on the merits, then what makes it wrong for the former Boley commissioner to have said, more or less, people are entitled to their religious beliefs, but the civil rights, those that protect against discrimination, will be enforced? Isn't that more or less an accurate statement of what the court ultimately did decide, and therefore not a violation of a neutral standard, but instead just a generalized statement about what the law is? So if we got the law right, what's wrong about what the Commissioner Avakian said?
Well, 2 responses. First, the court in Masterpiece clearly says that this religious neutrality is a threshold question. It has to be addressed regardless of the merits. And of course, the Masterpiece Court didn't reach the merits in that case. But here we think the precedent from the Oregon Supreme Court is actually quite clear, and Commissioner Avakian got it wrong. And that's one of the things that we think this court needs to address. Avakian said having one set of rules is essential because it assures people are treated fairly. We think that is inconsistent with the Oregon Supreme Court's decision in Hickman, which said that parties who present an as-applied challenge to a generally applicable and neutral law must make an individual claim to exemption from that law on religious grounds. That wasn't a standalone decision. They were quoting other cases from the Oregon Supreme Court. And that is inconsistent with Commissioner Avakian's view. Someone who's already said there can be only one set of rules has ruled out the possibility of a religious exemption. After prejudging their claim, how could he then give full and fair consideration to the religious objections that had been raised? Commissioner Avakian was not the only one to exhibit hostility towards the client's beliefs. The bully prosecutor said that the clients have continually used their religion as an excuse for not serving complainants. Bully doesn't deny that this statement expresses hostility toward the clients by characterizing it as merely rhetorical. That's what Masterpiece Cake Shop said is indicative of hostility towards religion.
And can I ask you a procedural question about that point? In your briefs, you pointed out that statement by the prosecutor, and Boley's response was that that statement should not be attributed to Boley, it should be attributed to complainants. In Masterpiece, though, the Supreme Court looked only, at least as far as I can tell, at the statement of the commissioners. To what degree, and I'll ask this of both sides, does Masterpiece require consideration of the statements of the Boley prosecutor as distinct from the commissioner, and why?
Well, Boley said that the people in the client's position are entitled to neutrality and respect in all the circumstances of the case. We think that means that everyone who's involved in the case needs to demonstrate respect and neutrality. But this is not like a civil trial where you have a separation of powers between the judge and the prosecutor. Here, both the commissioner and the prosecutor work for the same commission.
So I guess that kind of dovetails into the question I was going to ask you, which is it your theory that for what we're going to call the Boley prosecutor, their statements come into this neutrality mix because of the structure of how Oregon Boley is conducted?
Well, that's one answer, but I think the other answer is that Commissioner Avakian himself cited this response to interrogatories in his order, and in the very next paragraph said that he had reviewed the entire record. It was significant in Masterpiece Cake Shop that the other commissioners on the Colorado Commission had not objected to the hostile statements of the minority of commissioners in that court. And so we have the same problem here. Not only did the Boley prosecutor treat the client's religion as an excuse, as something merely rhetorical and insignificant.
So the other question that I had, and this goes more to dealing with specifically with Commissioner Avakian and his statements, this isn't the first time this court has dealt with those statements. We spent 8 or 9 pages of the original opinion discussing Commissioner Avakian's statements in the context of whether due process required him to recuse himself from the original case. And so I guess it would be helpful for me to know, in light of Masterpiece, right, what of our rationale and decision-making under the due process standard doesn't get or fails to approach the legal question that Masterpiece requires that is separate from due process? And are there facts that Masterpiece would require us to consider that we did not consider in the due process context?
Yes, so I think 2 answers. One is that Masterpiece sets a very high bar. Even subtle departures from neutrality are indicative of a violation of the Free Exercise Clause.
If that were the case, though, if subtle departures were enough, why did Masterpiece need to string together a long series of events and then arrive at essentially a totality of the circumstances? Because no individual act in Masterpiece was called out as that's enough, correct?
Well, there was no need for the court to do that because, as you point out, there was more than one piece of evidence. And Masterpiece instructs, I think, that the court is to look at all of the evidence as a whole. That doesn't mean that no particular piece of evidence would be sufficient. Lukumi, which Masterpiece cites, says even subtle departures, even the bias doesn't have to be overt. Even disguised instances of bias are sufficient to violate the free exercise clause.
Can I ask a question there? When you talk about the totality of circumstances, are you opened referring to 5 possible indicators to you? I'm looking at Masterpiece and doing case matching, which as attorneys and judges we all do more for whatever value that might be. But there's a couple of factors that I noticed that were significant in Masterpiece. One was that the U.S. Supreme Court was unsatisfied with a couple of the answers that the Colorado Court of Appeals gave in dealing with inconsistent decisions and whatnot, and in not saying anything at all about what the commissioners had to say that seemed to evidence a religious bias. So my first of 2 questions is, if we think about the Colorado Court of Appeals decision, you've now read our Oregon Court of Appeals decision. The Colorado court, there were things to talk about. Now, I realize, and again, I respect the disagreement that the clients have with our court, to be sure, but do you find in our decision any indicators of a religious bias or a non-neutral attitude in our decision, as was pointed out in Colorado?
Well, I think there are a couple of aspects of the decision that the Supreme Court could interpret to indicate a departure from the strict neutrality standard that Masterpiece sets. I would point to 2 things. One is that the Klein 1 expressly endorses Bowley's treatment of Aaron Klein's quotation of Scripture as the basis for the damage award. The Klein 1 says, Bowley's final order reflects a focus on the effect of the word abomination on the complainants, including their recognition of that biblical reference and their associations with the reference. We think that's problematic under Masterpiece for a couple of reasons. First, Bowley treated Aaron's conversation with Cheryl McPherson as part of the denial of service, which we think is inconsistent with the facts, as found by Bowley. Cheryl McPherson returned to the store alone after the denial of service without an intention of getting a cake from Aaron or convincing him to change his mind about the cake. She was very clear throughout the proceedings about her intention. She said that she wanted to tell him what she thought, to open his eyes a bit, and that she saw this as a teaching moment. And that's exactly what she did. When she got into the store, she explained how her truth had changed and that she believed the Bible to be silent about same-sex relationships. It was only in response to that conversation initiated by a third party that Aaron expressed his own religious views. And for that, the Kleins have been punished with a $135,000 damage award, an award that even the Oregonian has called exorbitant, and a death sentence to a business as small as theirs.
And thank you for mentioning that. Now, I'll put on hold because I have a second question about case matching. It has to do with inconsistent decisions, but let me come back to that. Because since you're identifying the damages issue, that's of interest, of course. And so my question there is, you've identified now, after the case has already been up through this court once before and back, this issue that you've now described as the damages as being as if it were a punishment for the religious quotation. I will leave it to the state, if it wishes to respond, as to whether, in fact, what was going on there in that portion of the Court of Appeals decision or in Bowley's order was a distinction between whether it was the damages related solely and strictly to the extent of emotional distress caused. And a lot of the discussion may go there. I'll leave that to the state to respond. But my question here is a procedural one. Your clients had the opportunity when the award of $135,000 total was suggested and recommended by the administrative law judge and when it was before the Bowley commissioner to file objections to the proposed final order, and did object. But the objection had to do with, the objection that the clients at that time presented had to do with the fact that it was a dispute about whether Mr. Klein's quote was misrepresented by complainant's mother, that he didn't actually say that, that the complainants were an abomination. He was merely quoting the language of Leviticus, right? the objection raised was that the damages shouldn't be awarded because it was a misrepresentation. But that's not the same argument that we're hearing today after the opportunity to present objections, which were required. Now seems to be an issue of a new argument saying these are damages simply for the speech. So my question to you is, wasn't there a failure of the Kleins to have presented the objection at the time that that damage award was recommended to the Boley Commissioner? Wasn't there a failure to preserve that issue? And don't we have a problem in entertaining this argument today because it was not preserved before? Not presented before?
No, we don't think there's a preservation problem here. The Kleins very consistently and throughout the proceedings opposed the damages award, and they did so on the ground that it was not, that it did not accord with the facts that actually happened. So the argument that we're making here is part and parcel of the argument that they've made consistently throughout this proceeding.
Well, can I go to this?
Can I ask just a follow-up there? I'm actually looking at the client's exceptions to the final order on page 26, and the argument was that the findings concerning the statement about your children are an abomination and the reactions to it are not a result of the denial of cake services. Is your argument that that exception, that aspect of the claim damages were not a result of the denial of cake services is what presented the issue at that time?
Thank you, Judge Lageson. Yes, that is, I think, a good example of how the Kleins have preserved this issue.
If I can just, forgive me, the second question I'd hope to get your help for was looking at other indicators, Colorado comparing to Oregon. One of them in Colorado was the big problem that the U.S. Supreme Court identified in that there were inconsistent decisions from that state's labor, or its human rights, civil rights commission, in fact, involving questions of cakes and messages. And that was the issue that the Colorado Court of Appeals dealt with only dismissively. The U.S. Supreme Court was unsatisfied. And so the fact that the agency had inconsistent decisions was a big part of the problem, not just the comments of the two commissioners in the process. So have you or your clients identified inconsistent decisions of Oregon's Bureau of Labor and Industries on this question, like there were inconsistent decisions in Colorado? What are the inconsistent decisions here on this issue by the agency?
First, that kind of inconsistency was not essential to the court's decision. The court didn't identify that as necessary. It rather looked at that in conjunction with the other evidence. But there is evidence of inconsistency here of a different kind. Boley's bias is evident in the disproportionate damage award because it didn't follow its own precedent in how it calculates damages. The boilerplate language that's quoted on page 44 of the ER says that in determining damages, Boley considers the type, duration, frequency, and severity of the conduct and the type and duration of the mental distress. But if you look at the comparator cases that Boley relied on, none of them line up with the client's case along any of those dimensions.
And I want to pursue that, but let me make sure I understand your answer correctly. I think you're saying, no, we don't have any inconsistent decisions on the
legislative body, there's the presumption of regularity that attaches, and then it's the petitioner's burden to establish why those procedures weren't followed. I mean, in the case of bias, due process bias claim, it's that the petitioners have to show actual bias. So I think here it's a similar legal scenario where it's the petitioner's burden to show actual hostility by the bully commissioner to their religious beliefs.
So, Mr. Whitehead, I would like to call your attention to page 36 of the Boley Commissioner's final report.
Okay.
Beginning at line 18. From February 1st, 2013 until the time of the hearing, many people have made hate-filled comments, and it goes on to say, that were supportive of respondents. How can I interpret that as anything other than those who were supportive of the Kleins were motivated by hate? And how can I do anything other than interpret that as a bias against the Kleins' sincerely held religious belief?
So I believe that section of the order is talking about
That's in the factual findings.
the social media responses and kind of the furor that surrounded the cases.
But doesn't that sentence equate those who would support the respondents as being motivated by hate?
It certainly uses the word hate, and I think that's probably a fair characterization of kind of the vitriol that surrounded the public commentary about this case at the time. I don't know that characterizing a hateful comment as hateful is prescribes that emotion, that characterization to the Klein's religious belief specifically. That's not. I don't read the statement as having that effect. And that's also not a point that petitioners have
Fair
raised.
enough. I fully realize that I've surprised you on this, and I appreciate your answers to that. And I don't want to distract you any longer, so please.
Sure, but so I think I would say that the order and the findings, and there was lots of discussion throughout the administrative process about the media aspects of this case and whether complainants could receive damages based on the effects of that. And what the ALJ said and what Boley ultimately did was say, no, we don't have authority to award any damages. So I think that essentially fell away as part of the case.
Yeah, I had a question about that too, and I think you've probably gone on to probably a more important point, that damages weren't awarded for the press-related coverage anyway. But I guess Judge James' question has to go, is whose characterization is it to say hate-filled? Because hate-filled is in quotes in the order. The commissioner there in the factual findings is apparently quoting somebody's testimony about that. And so when I read that, I don't know whether to take that as the commissioner is casting the judgment that these may or may not actually be such vitriolic statements that he regards them to be hate-filled, or it could be because it's in quotes, he's quoting a witness, perhaps who's describing her emotional distress, and the witness regarded it as hate-filled, and that's why it appears in this portion of the order to describe how the witness who's reading that regarded that and why that all relates to distress and money damages at the end. So I'm not sure if you can help me with a transcript as to why that's in quotes, and is that really the commissioner or is that quoting a witness?
I'm sorry, but I'm not aware if that was quoting a witness. My assumption in the findings of fact is that it would be a quote of the witness, but I'm just not sure. So since you're having record questions, I would like to talk about how this court should view the record. And we are in an unusual procedural posture because essentially none of the arguments of religious hostility, as it's brought before the court by petitioners, were raised in the first go-round, and they weren't raised in their current form before Boley. It's only after the United States Supreme Court has said, well, go back and reconsider what you've already done in light of Masterpiece Cake Shop.
But do you disagree that that's the job that the United States Supreme Court has assigned us, is applying its analysis in Masterpiece to the record in this case?
I think that's what the Supreme Court has said to do, but that doesn't mean that this court disregards Oregon law on how arguments get developed. I don't think that's a statement from the Supreme Court that state procedural rules no longer apply. And I think, so to the extent, I mean, if the question of we have a record and there are ambiguities, I mean, I don't think there are ambiguities on this record, as petitioners have brought it up, but if there are ambiguities, there wasn't any factual development by the petitioners on this issue, and I think that should cut against them. This court shouldn't resolve ambiguities against Boley again when we haven't had the chance to answer to those and in a fact-finding forum.
What about preservation of error? If that's an issue, notwithstanding Masterpiece Theater, that of course we're required to go back and look at this as a free exercise violation, was this a neutral proceeding that occurred? But if looking at that, what do we do about issues that are presented such as, well, look at the damage award. By golly, it's a lot of money, and we think speech is now punished. Do our state law principles of preservation of error go out the window, or do we need to still observe those standards when we go back and look at this record to see what were the objections that were raised to the commissioner's order? Were they, talking about, punishment of speech or what?
Well, I mean, this court has an independent obligation to assess preservation of error principles, and in cases that I'm aware of where the Supreme Court has remanded to our state courts, both this court and the Oregon Supreme Court have considered preservation principles. I'm thinking of the Williams versus Philip Morris case, where on remand for the United States Supreme Court, ultimately under an Oregon state law and under Oregon preservation principles, the court didn't reach the issue that was on remand from the United States Supreme Court because there's a state law answer. And that's ultimately this court's job in the first instance, I think, is to apply state law. And if that provides an answer that's sufficient, then it's sufficient.
I want to sidetrack you real quick, and it would be helpful to me to get your perspective on how the standard set forth in Masterpiece for neutrality across the proceedings is applied in Oregon's context of how Boley operates, where there is a commissioner that sort of directs the initiation of a prosecution, and then someone who reports to that commissioner conducts the prosecution. It goes to an administrative law judge who's separate, but then it comes back to the commissioner who can modify the order of the administrative law judge. And so is there room for advocacy in that model under Masterpiece, or is that thread of neutrality applied to all of the players who touch that case because of the model Oregon has created?
Well, I mean, there's absolutely room for neutrality in that process.
Room for advocacy.
Room for advocacy within a neutral process. I don't believe Oregon's process is all that different from the process that was used in Colorado, although I'm not as familiar with Colorado administrative procedures. And to me, your question really goes to a due process issue of, can you have, a fair adjudicator, like a combined prosecutorial function and adjudicatory function in administrative law? And that hasn't been questioned in this case. And I think big picture, there's lots of case law that says there's no due process problem. And I think that ultimately, if we're talking about, neutrality writ large, there's no issue there. And so I think the problem in Masterpiece was specific statements by the Colorado Civil Rights Commission that exhibited clear hostility towards the Bakers' religious beliefs in that case, coupled with the disparate case law treatment. And
let me make Judge James' question a little bit more concrete, and it goes to the question of whether statements made by the Boley prosecutor should be taken into account in conducting the masterpiece inquiry in neutrality. And sort of besides the interrogatory statement identified in the briefing, one of the arguments that the prosecutor made during closing argument was to draw up a newspaper article about the Civil Rights Act and quote it and say, Oregonians are free to harbor whatever prejudices they choose. The civil rights law does not attempt to control prejudice. Rather, it outlaws overt laws of discrimination and public accommodation. That's exactly what's going on here. So the prosecutor compared the client's religious beliefs to prejudice, something somewhat similar to what the Supreme Court found objectionable in Masterpiece, at least when those statements came from the commissioners. Should the fact that the prosecutor made that comparison in this case bear on our assessment of whether the government was sufficiently neutral here?
Well, so I think the first answer is that there is a division between prosecutorial and the decision-making functions, that statement was made in front, it was as advocacy, as argument in front of the ALJ, who ultimately decided the issues that were before it, and then that were decided in the Boley final order, and that then got reviewed in this court.
Isn't the commissioner sort of the head of the agency that the prosecutor represents?
That's right.
And does the commissioner have any authority by statute to control the prosecution?
I mean, it is a complaint by Boley, and the prosecutor is a Boley employee.
And there are points in closing argument where the prosecutor said this is the agency's case brought on behalf of the state of Oregon, correct?
Right. So, I mean, but ultimately, those arguments were way before an ALJ. So I think there is a divide between the prosecutorial function and the agency sitting as decision maker.
The ALJ's order isn't final, though, is it? I mean, because then it can be amended because it goes back to the commissioner.
That's correct.
So ultimately, it's the commissioner who's the final decision
It is
maker.
like the ALJ is an intermediary who makes factual findings and preliminary conclusions of law, and it does ultimately go back to the agency for final decision, and then it comes up on review before this court. I mean, and again, I haven't looked at the statements in context, but in the context of civil rights laws, we're talking about discriminatory conduct and what the civil rights laws do, and this is all over the Masterpiece decision, is saying those laws are legitimate state efforts to protect the dignity of the people who are protected classifications under those laws. And so in a prosecution for a civil rights violation, words like prejudice and bigotry and discrimination are going to be used. I think But
isn't that part of what the U.S. Supreme Court said was the problem in Masterpiece, where you have the rights of two parties bumping up against each other, where you have the rights of same-sex couples under the anti-discrimination laws, and you have the rights, in this case, of the bakers under the religious freedom laws, and there's a clash. And the court seemed to say through that the anti-discrimination laws are a very important part of how we make our world work and can be enforced, but there needs to be respect for the religious freedom rights too.
And that's right. But I don't see what Boley comments here by the prosecutor or anything in the final order or by Commissioner Avakian as disrespecting those religious beliefs. I mean, I think there's a difference, and it's can be a close line between belief and then the conduct that's motivated by that belief. But that is the heart of this case, is that what's prohibited by the public accommodations law is discriminatory conduct. And when you're bringing in evidence to consider whether conduct was discriminatory, sometimes that will involve testimony about beliefs. It will involve the words that the accused have used, and that's why the word abomination has been was an important part of this litigation, is because the words used, even though it was a word that came from a religious text, it had a causal effect on the complainants, and it caused emotional harm.
Let me go back to Judge Lauguson's focus on the choice of the word prejudice and discrimination, if I can, because I think we may be begging the question, but it's the same question that I posed to Klein's counsel at opening, which is to the extent that that question may seem to be itself biased, or to the extent it's assuming the truth of what the ultimate outcome is. What I'm trying to get out is if our understanding of what the discrimination laws are is something that both protects civil rights and considers defenses, whether they're First Amendment or or speech or religion, and those are all respected, the result still will be an enforcement of civil rights, and the results could be a conclusion on the merits that there is, in fact, discrimination. So I hear a prosecutor saying, we've got discrimination here, and you've got an advocate who's on one side prosecuting, you've got defense folks on the other side defending, ably so. But what I'm trying to get out is, doesn't something that's going on here involve what the ultimate answer is on the merits as to whether it really is or isn't discrimination? So is that question from the prosecutor necessarily a biased, it may be a piece of advocacy, but the advocacy could be true if the prosecutor turns out to prevail. Isn't that right? So it could, in fact, be discrimination if that's what the answer is at law on the merits. Is right?
Regardless of the description of the argument, is that?
Yeah, what I'm trying to say is the prosecutor taking that point of view of advocating that what we've got here is discrimination, and that's, the complainant point of view, that's the prosecuting point of view in a quasi-judicial proceeding, court-like proceeding on both sides. I mean, isn't that statement, although it could be seen as disrespectful of religion, also being, in at least the view of the prosecutor, being one view of what the law is? And could it not turn out that, in fact, that could be the law, whether this court says or the U.S. Supreme Court says so? But if the prosecutor is right that what happened here is, in fact, discrimination, is that statement by the prosecutor to be seen as bias or simply advocacy of what could be the right answer?
Right, and of course I would say simply advocacy of what would be the right answer. And that's where, again, the focus on Masterpiece was on the statements by the decision makers. And the problem with the different case law was that it wasn't adequately dealt with by the decision makers, by the Colorado Court of Appeals. I don't know if that answers your question, Your Honor.
Yeah.
Can I shift some gears into some questions about the damages award in particular? So in the Church of Leukemia Babalu I, one of the things the Supreme Court stated that those in office must ensure that the sole reasons for imposing the burdens of law and regulation are secular. And in this case, it's undisputed from the commissioner's order that the damage award was based in part from the conversation Ms. McPherson had with Mr. Klein after returning to the shop after the initial denial of service, where if I'm understanding the findings correctly, she reported that she used to have similar beliefs but then had 2 gay children and changed her beliefs. And then he responded by quoting Leviticus, and then that was relayed to the complainants, which then caused distress. And my question is, in basing the damages award on that conversation, what standards did the commissioner employ that demonstrates he met the obligation recognized by the Supreme Court and the Church of Leukemia Babalu I to ensure that they were imposed solely for a secular purpose and were not imposed in part to punish Mr. Klein for his religious beliefs?
Well, so Boley viewed the denial of services as encompassing that conversation as a factual matter, that the manner in which services were denied included this conversation, and so the commissioner treated it as a purely factual issue for what caused the complainant's damages.
And sort of just I guess this is a procedural question following up on that. So Boley did treat the denial of services as encompassing both parts of that interaction. There was an exception to the proposed order that raised that issue. I didn't see that the commissioner expressly addressed that argument in responding to that. And to what degree does sort of not responding to that particular exception, have any role in the masterpiece calculus?
I don't think it does. I mean, to me, our view of the emotional damages piece is that it's a purely factual question of what was the harm to the complainants. And as I understand the final order's reasoning, is it viewed the denial of services as continuing through that conversation. And I don't recall the order specifically addressed the exception, but I think plainly it treated the final order, treated the denial of services as continuing. And again, that's not something that came up in exactly this form. And when this was briefed the first go around, when petitioners had a chance to challenge the damages award, kind of for those for substantial evidence and substantial reason, the decision that this court has already made.
But again, I guess back to my original question, in this case, there is a conversation about religious beliefs that led in part to the damage awards. And again, standing back from it as a reviewing court, if we have some obligation to ensure that government officials are acting neutrally, what do we look at to ensure that obligation was met?
Well, one, I think you start with the presumption that the proceeding was conformed to the commissioner's constitutional obligations, and then you look for what's the evidence that the commissioner did something other than what the commissioner said he did, which was look at the facts of how the complainants were injured by the denial of services. And part of that was being injured by the use of the word abomination. And that's a causal question. I mean, this all the time, courts rely on the words people say to assess criminal liability, to assess damages. And that's not...
Well, would there be a difference between, say, criminal liability and damages? I mean, in a criminal case, usually the penalty is set by the legislature. It's relatively predictable, and so you can't really come back and say it was based on an impermissible purpose because they tend to be defined by matrices and the like. In this case, how do you assess what this amount of damages, do you agree that there's a subjective component to the assessment of emotional distress damages?
Well, I mean, this case, the merits was decided on summary judgment, and there was 6 days or 5 or 6 days of testimony about the emotional damages suffered by the complainants. And so in terms of how you value emotional suffering, I think there is some subjective element there, but it's one that's susceptible to proof. I mean, it's trying to understand what happened in the emotional and mental state of another person. And, as this court's case law says, when you're looking into the mind of a person to determine intent, it's difficult to do, and it's difficult to get concrete evidence of that. And so we rely on testimony and inferences you can draw from that testimony. And all the evidence here was about the harm that the complainant suffered by the manner in which services were denied. And I feel that just to say that denial was improper to rely on abomination because that's a word that came from Scripture would be to kind of set a presumption that any time you considered that harm followed from speech or from a religious expression, then there's a presumption that it's used for a bad purpose, or that it's not neutral. But that's not my understanding of the standard. I don't think that's certainly not what Masterpiece did.
Are you aware of any other cases, and probably not in Oregon, where this issue of assessing emotional distress damages flowing from the expression, emotional distress damages for harm flowing from the expression of a religious belief have been assessed? And if so, whether there have been any sort of standards imposed to ensure that it doesn't impermissibly cross the line from compensating for harm to punishing for expressing religious beliefs?
I'm not aware of other cases addressing that point, but I think there is Oregon case law talking overall about the effects of speech and the divide between punishing someone for the content of their speech and punishing someone for conduct that is evidenced in part by the words that they've used. And it's clear that that a person can be punished for their conduct and for the harm that follows from their conduct, or an injured person can be compensated for the harm that follows. And that's an issue of proof. It's an issue of evidence.
Go ahead.
Before you run out of time, I want to ask you one question about the range of permissible or possible remedies in this case. So if we were to conclude that there was a masterpiece problem somewhere in this chain, right, where would we need to send it back to? Do we have to send it back to the beginning? Is that the only option? Could we send it back to a point after the ALJ's determination, but before the commissioner essentially gets involved to accept, alter, or amend that recommendation? Would that be sufficient, particularly in light of the fact that there is a different person occupying that commissioner's seat?
I think that's a question that's a little hard to answer in the abstract, because I think it would depend on the nature of the masterpiece violation. For example, this case had bifurcated liability and damages. If there was no problem with the liability piece, I don't see why this court would remand for a reconsideration of liability.
To that end, do you read anything in petitioner's argument attributing bias to the ALJ component of this case?
I do not. And going to a question that was asked earlier, I don't see anything in their briefing that suggests a masterpiece problem by the ALJ or by this court. So I think as a scope of a remand would depend on the violation. But for example, if this court were to think that abomination was really a problem, a remand to consider, well, what's the damages excluding that word that was problematic, because there was lots of testimony about the damages, and there were several pages in the final order assessing damages for each of the complainants, and that was only a piece of it. So if this court has no further questions, the Bureau of Labor and Industry asks that you reaffirm the opinion that you've previously issued. Thank you.
Thank you. We'll hear a rebuttal.
If I might, I'd like to ask counsel to pick up where the respondent left off, because I had the same question as Judge James about remedy if we did find a masterpiece problem here, because it seems like there's two different issues. One is the liability side of the case, and the other would be arguably the damage side, assuming that's preserved, and there's a factual issue there. But if there were a problem with the former Bowley commissioner's comments, would a remand to the new Bowley commissioner cure any problem insofar as the liability side of the issues go?
No, a remand would not cure the problem, and Masterpiece is quite clear and emphatic even about the remedy here. The only remedy is reversal.
You mean flat dismissal of the case entirely?
Flat dismissal of the case. That's what happened in Masterpiece, and that's what the court said. The court said that the commission's...
Did the Supreme Court
The Supreme Court
say that the Colorado had to dismiss it, or was that the decision of Colorado once it went back there?
The Supreme Court said that on page 1732 of Masterpiece Cake Shop. It said the commission's order must be invalidated. It said it in another place, the commission's order must be set aside. That is the only proper remedy here, and the clients have been put through too much to have to endure all of this all over again.
Well, but we set aside a lot of things and send it back to go through the process again. Setting aside something and ending a case altogether are two different propositions. So what actually happened when it went back to Colorado?
When it went back to Colorado, my understanding is vacated the judgment of Oregon, and that was the end of the matter. The commission in Oregon brought another case against Jack Phillips, but that was a different case. That was not the same case, and it was based on a different factual predicate. So that case was dead after the Supreme Court issued its decision. That is the only remedy that the Supreme Court allows here.
Can you give us any case precedent for a flat dismissal of the case Because it seems as if when there's a procedural irregularity, let's say in a trial, the common thing is simply to retry, and it's a very typical thing. So it seems like if there's a problem with neutrality in statements, were you to prevail on the remarks involving the commissioner, that the question would be to redo matters before a neutral decision maker. We don't, if there's been double jeopardy in a criminal proceeding where a case has been dismissed, you can't refile. But why would you have a double jeopardy sort of flat dismissal here?
Well, I think
What precedent do we have for that?
I don't have a precedent for you. I think the reason that the court selected the remedy that it did so emphatically is that it realized when the problem is bias, it's difficult to have a redo that can assure that bias won't be present, even when the commissioner is a different commissioner. Because as we've seen, this is not just one man, but an institutional problem that the clients suffered through. And so it wouldn't be fair and it wouldn't be consistent with the Free Exercise Clause.
In a criminal case, when there's been evidence of governmental bias, say, for example, through an improper juror exclusion and what should have been a sustained Batson challenge, what's the remedy?
I think generally they would put it before a new judge.
So why wouldn't that be an appropriate remedy here?
Well, I think the main reason is that that is not the remedy that the court said is appropriate in this case. I think the court's indicated how critical neutrality is under the Free Exercise Clause in indicating that the case cannot be brought again. Masterpiece Cake Shop doesn't require clear hostility. Masterpiece is clear that even upon slight suspicion, the Free Exercise Clause is triggered, strictly observed, the court says. Neutrality must be strictly observed. And the court says that neutral and respectful consideration to which Phillips was entitled was compromised. Even mere compromise is sufficient to demonstrate a violation of the Free Exercise Clause. My opposing counsel has suggested that the standard for bias is actual bias. That's not even true under the Due Process Clause. Caperton, the Supreme Court's case in Caperton, said the standard is not actual bias. Instead, the inquiry is whether a reasonable judge in that position would be likely to issue a fair decision. So it's an objective and not a subjective question. And in this case, the Supreme Court of Masterpiece has demonstrated that the standard must be even more strict than in the due process context. As for the hate-filled speech mention, I think it's Boley's burden to disprove the natural assumption that the words that Boley used in its order should be attributed to Boley. There's no citation or suggestion that those words come from someone else. The arguments that we've made here in response to Masterpiece Cake Shop could not have been made in precisely the way that we're making them now, because Masterpiece Cake Shop did not exist. The court remanded for consideration of Masterpiece because Masterpiece is a new case. And so we should be making arguments that are inflected by Masterpiece Cake Shop. But as a matter of fact, we did raise many of these same arguments. In fact, in a different context, we've been accused of recycling the same arguments. So if you look at page 56 to 65 of our opening brief, many of the arguments that we've made here appear there in the due process context. If you look at Klein 1, the court acknowledges that we argued targeting on page 548 under the Oregon Constitution and 543 under the U.S. Constitution. Targeting, that is the language of Lukumi that the court is adopting and extending in Masterpiece. Of course, it's appropriate for a prosecutor to advocate for her position, but that's different from calling the Klein's religion an excuse. The Supreme Court has said that these sorts of comments, if you look at the dictionary says an excuse means a reason or explanation put forward to defend or justify a fault or offense. The implication is there that there's an underlying fault that needs to be defended. And Masterpiece said that such statements that disparage the client's religion by characterizing it as merely rhetorical, something insubstantial and even insincere, violate the free exercise clause. I'll return to the Bible quotation because this has been a topic of interest. I think I mentioned one of the reasons why this is indicative of hostility, and that is because, as the clients have consistently argued, Boley imported this into the denial of service, even though it didn't belong there. But Boley's treatment of Aaron's quotation of Scripture also favored the complainant's, quote, reasonable and very real responses over Aaron's views. That is suggestive of Masterpiece elevating, in Masterpiece's words, of Boley, elevating one view of what is offensive over another. And that is consistent with the other language that Judge Lageson pointed out throughout these proceedings. Masterpiece says that when a government agency passes judgment upon or presupposes the illegitimacy of one's beliefs, we're in the zone of violating the free exercise clause.
Can I get back to where we started, which is the legal standard? And, so Masterpiece Cake Shop sets out factors, which it drew from Church of Lucchini, Bob Blue Eye, that we should consider. The historical background, the specific series of events leading to the enactment or policy in question, the legislative or administrative history, contemporaneous statements. So it's a wide-ranging inquiry. If we conduct that inquiry, we review this record, and we reach the conclusion that the proceeding could have been not neutral, but we're not confident that it was non-neutral. What does, in your view, Matt, what's the standard? Does Masterpiece, if we don't know for sure, does it require reversal, or do we have to be confident of the non-neutrality in order to reverse?
No, there's no requirement of confidence. And in fact, the Supreme Court in Masterpiece indicated that there were indications of deviations from neutrality, that in some statements cast doubt on the neutrality of the adjudicator, and that was sufficient. Recall that in Masterpiece, only a minority of the commissioners on the Colorado Commission actually made such statements.
What is the effect then on the state's policy of enforcing its cases, its statutes against discrimination on any variety of grounds? If the proceeding is flawed, does that mean then that the state is unable to provide a remedy in a case that may be discrimination?
Well, I think Masterpiece Cake Shop doesn't set new rules for all possible discrimination cases.
I'm just asking your position. I mean, if you're saying our standard is so low that it looks like it's possible, we can't say for sure, it's possible that the proceeding was flawed, that means that the attempt at finding a remedy that an aggrieved Oregonian may have, the attempt at finding a remedy is denied. There just won't be a legal answer, right or wrong, for that complainant or the person accused. There just won't be an answer because the proceeding was flawed and we just can't do it over. That's your position?
That's correct, and this places an incentive.
That cannot possibly be the answer.
Well,
And I will observe that we are past your time. I will let you respond to the pending questions, and then we will conclude.
So there's no remedy for someone, even if there's just the specter of impropriety?
first, we're not in, this is not a case where the court has to address that question, because here we have clear evidence of bias on a number of different fronts, many of which did not even appear in Masterpiece, including the damages award, the gag order, the prosecutor's statement, and the treatment of Aaron's quotation of the Bible. This is not a case where the court needs to answer this question. But I think Masterpiece does set a very high bar because it wants to put an incentive on the people who are doing the important work of administering anti-discrimination statutes to ensure that they take great care not to tread on the most important liberties that the Constitution protects. Thank you.
Thank you.
Thank you. Thank you both for your arguments. And again, thanks to the Friends of the Court for the amicus briefs. The case just argued is under submission, and we are adjourned.
All rise.